does want to work. And particularly, I think there is a need there too, when it snows, just as it has done this week, when it blows, when there's work that needs to be done in the summer, when there's grass that needs to be cut or other things that need to be done, having someone that is familiar with the system, familiar with the city, familiar with the technology that's being used, I think is very valuable. So I would urge you to reinstate Mr. Courier as what we have on the grievance. It's one of those things, you have the power to do it, just as you have the power to say no. But I would urge you to say yes. I think it's good for more people. I think it's not only good for Mr. Courier, I think it's good for the city employees that are here to have the help that they need to have to accomplish their work. I think it's good for the citizens of this community to have the jobs done that they expect to have done in a timely fashion, in a proper fashion. So, again, I would ask that you reinstate him. And I'd be happy to answer any questions that you would have also.
Terry, do you wish to express an opinion about this grievance?
The grievance, which I think Mr. Sarvey relayed to you, was factually, there's some factual inaccuracies in it, and there factually doesn't raise a cause of action that the city feels is grievable at this point. The city was exercising its full and unrestricted management rights that are granted to it under the collective bargaining agreement, and they feel they haven't violated any of the terms of the CBA, collective bargaining agreement.
The union would argue contrary to that, obviously, that
Do you agree that they have full and unrestricted management rights granted to them in the CBA?
they have rights granted within the collective bargaining agreement, but not full and unrestricted rights that they have to follow the terms and conditions of the collective bargaining agreement.
I'll point you to Article 5 that indicates that the city does have full and unrestricted management rights to do these types of things. It's clearly set forth in the collective bargaining agreement. Further, the grievance is inaccurate in many senses, where it cites articles about termination and discipline and discharge when I'm not aware that any of that had occurred. So there's factual inaccuracies that we would ask the union to correct. But at this point, my recommendation to the city is that you were exercising your full and unrestricted management rights pursuant to your collective bargaining agreement.
Well, and I would point to Article 21.4, and there it says the word layoff shall mean a reduction in the working force due to the decrease of work or budget cuts.
Well, respectfully, though, it was a good deflection of my question as to whether or not Article 5 granted the city full and unrestricted management rights.
Within the limits of the agreement that is signed by the city and the city is a party to.
You have the agreement.
Yes.
You could certainly read Article 5 to the council. It's pretty clear.
That is part of it, but one part of it does not make the whole. So, and again, if we do not agree, there will be an arbitrator that will decide the issue. And your council will argue before it, and our council will argue before the arbitrator. And
respectfully, though, I'm asking you to correct the statement of the grievance to be accurate, because if you file a frivolous grievance, we're going to ask for fees and costs, because a lot of those issues that you're referencing there, I'm not aware of any of the minutes or anything that reflect anything that are reflected in your grievance. Reference to termination, for example, discipline or discharge, I'm not aware that any of that had occurred. And I would ask the union to present those facts so that if it did occur, that the council could act upon those.
The union has filed the grievance as it sees appropriate that we have there.
But I'm asking you to support factually what you're indicating, because I'm not aware of any facts that support a number of those allegations. So how can we accurately respond if factually you haven't given us anything that said that the employee was disciplined, and you're claiming the employee was disciplined and discharged for exercising his union rights. Where is that factually supported? Show me some minutes or something that the city has done to support that allegation. Certainly, I agree that you can grieve this. What we're asking for is facts to support your grievance. We've asked you for that. I haven't seen it. Certainly want to be understanding. But you're not allowed to file a frivolous grievance either.
It's not a frivolous
Then
grievance.
please give us the facts to support all of those allegations that you're listing as alleged violations.
First off, this is not the setting for an arbitration here this
This is
evening.
not an arbitration. This is asking for a factual support of what you're saying. You're asking them to make a decision on these things.
Right, Jim, I think what our city attorney is saying, you reference Article 2, you reference Article 4, Article 9, Article 21. You aren't saying why you reference them. I believe is that what you're saying, Terry?
List of violations, Article 9, discipline and discharge. I'm not aware of any facts that support that the employee was disciplined and discharged in any manner whatsoever. My understanding that he was, there was no issues with discipline with this employee.
Is it correct that there was a grievance filed last March citing the same articles and that the city sustained the grievance and agreed with the union?
That is not accurate.
It was not accurate, but the city sustained the grievance.
What I'm asking you to do is provide factual information to support or limit these violations that can be dealt with. Some of these things, it's very difficult to admit or deny if it's just a one-word recognition. Factually, what are you asking for?
And it's like we talked about before, Jim. I mean, we talked before about how some things don't get past the first or second level. I mean, something like this probably just goes a bit beyond the one-page form.
It may, that's a standard form that.
That's a standard form, and that's fine, that's what you use, and I'm okay with that. But I guess the point our city attorney is making, you cite Article 2, Article 9, Article 4, Article 9, Article 21. Okay, Article 2, why? Article 4, why? Article 9, why? Article 21, why?
Article 2 is recognition. The union represents all of the employees that are employed here and part of the union. Article 4, the union security, again, we represent those individuals. Article 9, discipline and discharge, and I dare say that the individual has been discharged. And again, the individual went through this last March and is going through it again. Article 21 on seniority. The individual has seniority, and again, part of the layoff is part of the seniority language that we have there. And again, we're citing these, and we're saying, no, they are appropriate. And we're before an arbitrator, we will be discussing these, and we will be showing evidence, and all of that.
And then certainly then I would be pointing out with these minutes that we've actually asked you now for factual support of these listed applicable violations so that we could resolve this. If we get to an arbitration and you provide the facts at that point, I certainly will ask for fees and costs because I don't think it's appropriate. If you have the facts to support these alleged violations, I think the council is entitled to see them now rather than in an arbitration. It could get resolved if you provide the facts. If you don't, I'm certainly going to reserve the right to ask for fees and costs because I think it's something that is not unreasonable for the city to ask for.
So is adjustment required, remove all references of termination from employee's personnel file, reinstate the employee and make employee whole, and cease and desist from violating the valid labor agreement. That's what we're asking for a remedy on this.
I'm not trying to beat a dead